I would note for council's benefit that we do have Justice Watts on the video screen. Sometimes it's not clear the direction that the sound is coming from because it's coming from the speaker. So if you hear somebody asking a question and it's not readily apparent where it's coming from, you might want to turn to the monitor. And with that, we will start with Ms. Hahn.
Good morning. May it please the Court, Haley Hahn for Petitioner Appellate Bridget Romeka. In 2002, concerned about an ongoing nursing shortage and the dangers this posed to Marylanders' access to safe medical care, the General Assembly passed the Healthcare Worker Whistleblower Protection Act. The act serves to protect two groups: healthcare consumers vulnerable to activities, policies, or practices that violate Maryland law and pose a substantial and specific danger to public health, and healthcare employees who face reprisal for sounding the alarm about unsafe practices. The Act's protections are especially important in the context of radiation treatment for cancer patients, like the brain cancer patients implicated in today's appeal. As this Court recognized in Lark, the Act is a remedial statute, and as such, is to be construed liberally in favor of employees who blow the whistle, not employers who endanger patient safety by violating Maryland health law. To ensure robust coverage and serve this remedial purpose, the Act adopts contributing factor causation. As a threshold matter, reliance on the McDonnell-Douglas burden-shifting framework does not dictate causation under the Act. This Court's 2006 decision in Department of Natural Resources v. Heller stands for the proposition that contributing factor causation under Maryland whistleblower statutes, even when McDonnell-Douglas burden-shifting dictates the evidentiary burden. There, this Court observes a whistleblower action by the employee intended to overturn a personnel action also will succeed only if the employee shows, by a preponderance of the evidence, that the protected disclosure was a contributing factor in the decision to take the personnel action. A few lines after, in that same paragraph, this Court went on to observe that the evidentiary requirements of a whistleblower action utilize the burden-shifting paradigm applicable to employment discrimination claims as first set forth in McDonnell-Douglas Corporation v. Green. Heller should decide this case. It's true that while the Heller Court did not engage in a prolonged analysis of the causation issue, but it did recite the relevant causation standard, and that's sufficient for present purposes. Appellee's argument that McDonnell-Douglas stages would effectively be redundant if the causation standard were the same at both stages is unavailing. As emphasized in Ms. Romeka's reply brief, under McDonnell-Douglas, what shifts is the evidentiary burden, not necessarily the causation standard. The different evidentiary stages reflect the different burdens of proof the plaintiff faces. So, for example, at the prima facie stage, the plaintiff faces a less onerous burden of proof that serves to help ensure that claims that cannot even meet the plausible allegation standard under pleading are dismissed. In contrast, at the pretext stage, which takes place at the close of discovery, the plaintiff will have access to different kinds of information she would not have access to when she made out her claim. So it could be a higher burden there, but it's not necessarily a higher causation standard. The Supreme Court's decision in the same term as Bostock, a case I'll get to a little later today, in Comcast Corporation versus National Association of African American-Owned Media, made the point that because McDonnell-Douglas arose in a context where but-for causation was an undisputed test, it did not address causation standards. Further, although the Maryland courts have endorsed the McDonnell-Douglas framework in employment cases, that does not mean that this court has decided to interpret Maryland employment law lockstep with Title VII. It's a touchstone of the American jurisprudence system that it is emphatically the province of the Judicial Department to say what the law is. But under our federalist system, it is also emphatically the province and duty of the Maryland Supreme Court to say what Maryland law is. And in fulfilling this duty, this court need not and should not hinge its interpretation on the decision of the United States Supreme Court in interpreting an inapposite federal law.
So, to start with the statute then, it includes a defense. It says in any action brought under the Act, it's a defense that the personnel action was based on grounds other than the employee's exercise of any rights protected under this subtitle. How is that defense consistent with application of a contributing factor analysis?
So that defense simply reflects the burden shifting framework, that the employer will have the opportunity to demonstrate that the adverse employment decision was not affected at all, that the protected disclosure did not contribute to that decision.
But it doesn't say that it wasn't a contributing factor. It says it's a defense that the personnel action was based on grounds other than the exercise of any rights.
Correct.
So if that were true, if somebody said, well, it was based on these other grounds, but then somebody came and said, but a contributing factor was something else, how do those things match? How can they coexist?
So the best reading of the words based on in the statute is based on a lawful level. Here, any consideration of the protected disclosure is not a lawful level of considering. If the General Assembly wished to allow for any consideration of the protected disclosure, it could have used language like based on additional grounds, but it didn't do so.
What if the undisputed facts in the summary judgment record establish that the termination was based on those other grounds?
So, as a threshold matter, that's not our case. But if that were the case, then yes. Though I would say in the employment.
Would you agree that summary judgment on behalf of the defendant would be appropriate in that circumstance?
If those circumstances did arise, but I would caution that in the employment context where so much is based on circumstantial evidence, we don't live in the Molesworth versus Brandon world for the most part, where an employer will say, I am firing you in part due to your protected characteristic because you're a woman. So that's why it's critical in these employment cases that the case go before the jurors who can weigh credibility issues. So
what's the evidence in the summary judgment record that overcomes this defense that the Chief Judge identified in the statute? The Chief Justice identified in the statute.
In today's case, not the hypothetical? I'm sorry.
No, in this case,
yes.
What's the evidence in the summary judgment record that overcomes that statutory defense?
It's the timing, the treatment, and the testimony here. So throughout the litigation of this appeal, appellees have mischaracterized the timing of the termination decision. At times they pointed to May 10th. At other times they pointed to May 16th. And this can evidence pretext. There's also lack of contemporaneous documents substantiating the shifting timeline, as well as ambiguities in contemporaneous communications. For example, testimony that Dr. Jacobs asked that Ms. Romeka be removed has been construed as indicating that that was the point the termination decision was made. But based on the practice at RadAmerica, such testimony is ambiguous because RadAmerica, during Ms. Romeka's tenure and the tenure of her supervisor, Mr. Ozick, has not terminated anyone.
Well, there's an affidavit from Wendy Greer that says the decision was made. She was told that by Ozick and Rosen that they had decided to terminate her on May 10th. And the Greer affidavit says, I agreed with that after my own investigation as of May 16th, all of which is before anything came up about her complaining about the use of the manual use of the treatment table.
So I have three responses to that, Your Honor. First, that affidavit testimony was prepared in the course of this litigation. That means that a trier of fact could reasonably find to weigh it less than the contemporaneous documents, which is the second point.
Well, before you go beyond that,
Sure.
You had discovery and the opportunity to cross-examine or take a deposition of Ms. Greer and of the other two individuals, correct?
That's correct. I would qualify that I was not the counsel at that point.
I'm sorry, I understand that your predecessor counsel had that opportunity.
Yes. That's true. But even on the facts through discovery, there are still ambiguities here, and it is curious that there aren't other papers relied upon in the summary judgment record substantiating this May 16th opinion. That means it's the words confirmed used by Ms. Greer are ambiguous. It's unclear if she confirmed just with herself internally or if she confirmed with Mr. Ozick and Mr. Rosen about this. The third point I would just point out is the appellate court really relied heavily on Ms. Greer's affidavit. On page 49 of the opinion, the court emphasized if Ms. Greer had not made the decision to terminate, the termination would not have happened and the process would have ended. And given these issues with the affidavit that we have highlighted here in our briefing, having it play such a critical role just underscores how the inferences in this case were drawn in appellee's favor. And that's directly contrary to the summary judgment standard, which is for the moving party, for all inferences to be weighed against them. I would also point to this court's opinion in DeGrazia, where the court emphasized that issues of motivation and intent are generally inappropriate to resolve at summary judgment. This is so particularly in a case such as this where testimonial evidence is so key. Even the most talented scribe cannot capture all of the elements that a reasonable trier of fact would rely on in gauging the reliability of issues. That includes things like body language, tone, the manner in which particular words are said. For example, I do not recall could be a sincere reflection that someone does not remember, or it could be an evasive response. It's impossible to tell given the transcripts. So for this reason, it's critical that the trier of fact have the opportunity to weigh motivation and to draw their own inferences based not just on papers, but on the people themselves to weigh credibility. Because that's what this case is about, credibility. I would also emphasize, too, in addition to RadAmerica's policy of not terminating anyone prior to Ms. Romeka during Ms. Romeka's tenure or during her supervisor's, Mr. Osik's, that the issues with, for example, personnel policy, Dr. Fritz Lierma was also subject to concerns about interpersonal issues. And it wasn't just that folks threatened to quit. 6 radiologists or people who reported to him either directly or indirectly resigned, resulting in his demotion to a part-time physicist position at Mercy Hospital. But he continued working full-time for RadAmerica, and that's at E645 of the record.
Ms. Hahn, were there any employees who were not fired who had engaged in falsifying medical records, patient consent records?
Yes, there was, and this situation arose a couple years before the subject of this appeal, and it's covered at E66 and E790. And what happened in those circumstances was the supervisors came together. They decided to figure out a plan to prevent this from happening in the future, and they added an additional step in the form in the electronic filing. But it was a process level, let's figure out how to prevent this from happening in the future, so it wasn't a punitive termination that resulted.
I imagine that we will hear there may be factual differences in that situation, but I want to ask about the language in Section 502, that personnel action cannot be taken because of whistleblowing or protected activity. Chief Judge Bader discussed with you the language in the defense statute. I want to talk about the because standard.
Yes. So our position is that because establishes a causal nexus between the protected activity and the adverse employment action, but it does not necessitate but-for causation. Now that finding comes from the United States Supreme Court's decision in Nassar, where it found but-for causation synonymous with because. But simply because that is how the U.S. Supreme Court has interpreted this language, that does not bind this court. As we discussed briefly in our reply brief, such a finding depends implicitly on a finding that these statutes are in pari materia. And this court has been clear that simply because a federal and a state statute are similar, it doesn't mean they need to be interpreted lockstep.
What about just the plain language of but or because, the dictionary definition?
Yes. And our position there, too, is that that is still consistent with finding it just generally establishes causation. I would also point out, too, that even after Nassar, courts in other states across the country have interpreted because to require lesser causation standards and but-for causation. And in those states, one of the key things that those states tend to point to is liberal construction canons or liberal construction statutes, which are analogous to this court's observation. Yes.
interrupt, but I want to go back to Judge Booth's question about the plain language and the dictionary definition. I understood you to say that because could be interpreted to mean it's just a factor. I'd like to understand why you say that. The dictionary definition means because means the reason for, not a reason or a factor. Can you elaborate on why you equate the plain language of because to be a contributing factor?
Well, one reason is with respect to reading because in the context of the statute itself, and the fact that through the plain language of the statute as well as the legislative history, the General Assembly indicated that they wanted the statute to be construed broadly for protective purposes for the whistleblower. And as highlighted in Lark, as well as some of the scholarship we point to, contributing factor causation is critical in these employment cases, particularly for whistleblowers, to ensure that their claims don't get tossed out. And again, because these are protecting such vital public interests, it's not just the interests of the parties before the court, but also the interests of the public as a whole here in ensuring safe public health provisions, that really justifies that choice. I would also want to highlight, too, with respect to but-for causation, if this court decides to adopt but-for causation and is guided by Nassar, it should similarly be guided by the Supreme Court's decision in Bostock, clarifying that but-for causation is a but-for cause, not the but-for cause. In other words, but-for causation is not sole cause causation.
I want to go back to Justice Watts' first question and your answer dealing with whether anybody had ever been found to have falsified a medical record and not been terminated. Mm-hmm. I understood, at least I recorded that you pointed to E66 and E790. E66, and I might have heard that wrong, I want to make sure.
E662, sorry.
662, okay, because E66 is a portion of the record. But I did look at 790, and that discusses an incident in which somebody else forgot to put a consent in the record, but at least as I'm reading the transcript on that page, there's no indication that it was falsified. They just didn't put the consent in. Am I misreading that?
No, and it might be...
Because she didn't just forget to put the consent in. When she found out she didn't put the consent in, she then went back and falsified it to make it look like it had been in there in the first place, right?
She put the wrong date down for the dates that it occurred. That's right.
But afterward, in revising the record later in order to make it look like something had happened that didn't.
That's correct. But
So I want to go back then to Justice Watts' question, which is there any evidence in the record that anybody was found to have falsified a record, not just forgotten to put the consent in, but falsified the record and not been fired?
Not to my knowledge, but I would point out that comparator analysis isn't always precise and that it is so fact-bound that it is critical that it goes to the reasonable fact finder to determine if these similarities are similar enough to find that this was a pretextual termination. And for that proposition, I just point to the 2019 Fourth Circuit case, Hayes v. Waste Connections. So to the extent that this court is having difficulty reconcile perhaps the comparators in the record with others, I would just say, again, that is for the finder of fact. It's not so stringent, Ms. Romeka's burden at this point, that she has to find an exact comparator. Again, given that RadAmerica has not terminated anyone in nearly 2 decades at least, there isn't going to be an exact comparator.
Well, Ms. Hahn, I wasn't looking for an exact comparative. I was just following up on your argument that RadAmerica had not fired people to see if there had been a similar circumstance. I noticed in the extract on page 448 that there is information about accuracy of records that specifically indicates no one may alter or falsify information on any record or document. And this is part of the code of conduct of MedStar Health. And then employees are required to sign indicating that they received the code of conduct and that they would abide by it. So when I read that in the code of conduct, it gives rise to the inference that firing may be mandatory for falsifying information on any record or document. It's specifically prohibited in the code of conduct, and employees must acknowledge this. So can you respond to this?
Yes. I would say there that just given the timing when all this went on, even if firing were mandatory, it's still not clear based on this record and the close temporal proximity between when Ms. Romeka made her protected disclosure on May 17th and the termination decision by Dave Spearman at May 18th. Even if termination was mandatory, this close temporal proximity, it's still critical under the statute to make sure that her termination did not play a contributing role in actually making the decision to terminate.
It sounds like you're trying to utilize the lengthy, or I should say the careful deliberative process that the employer used in reaching this decision to the employer's disadvantage, because all of the facts and the key interviews and everything that informed the decision to terminate her occurred before this incident that your client used as the basis for her whistleblower complaint. And so they could have terminated her the day before based upon the exact same information. And I think that's a point that the circuit court judge made in his decision. And how do you respond to that?
They could have, but they didn't. And in engaging their HR process, there are several questions raised by the way they engaged in that. And the point of the HR process is not just to go through the motions, it's to actually go through a deliberative process to ensure that employees are terminated in accordance. And I'll point to two features that I think highlight this. The first is that Ms. Greer conducted an additional interview with George Casados on May 18th, despite in her affidavit, saying that she had made the decision on May 16th. Why continue interviewing people if you've already made a determinative decision? The second feature I would point to is that Mr. Osick was apparently in a room.
Maybe it could have changed her mind.
Maybe, but if you've decided, if an employer's representative has chosen to make a decision, that seems determinative. If it's operating in the determinative manner for which appellees seem to put forth this affidavit and which the appellate court seem to credit.
I just want to point out, you can keep going, but you are at this point into your rebuttal time.
Judge Gould, if you're satisfied with that response, and if no one has further questions, I can just wait till rebuttal. Thank you.
I see no more questions, so thank you, Ms. Hahn. And it looks like you're splitting your time 20 minutes and 10?
No, I'm going to be doing all 30, Your Honor.
Okay.
Our Chief Justice.
Please proceed.
Good morning, Chief Justice Bader, Justices of the Supreme Court. My name is Jennifer Curry of Baker Donaldson, and I'm here today on behalf of the appellees, namely RadAmerica and MedStar Health in this case. May it please the Court. Ms. Romeka is asking this Court to upend long-established law analyzing employment retaliation claims. The process she proposes for replacing that analysis is not only antithetical to the law, but it is unworkable in practice. Moreover, she is asking this Court to make such a leap based on undisputed facts that have repeatedly disproven the validity of her claim. The events leading to Ms. Romeka's termination relate back to events and conduct that occurred well before she made any alleged complaint on May 17th. It is undisputed that on May 1st, Ms. Romeka's supervisors initiated an investigation into her conduct and performance. It is undisputed that that investigation involved her falsification of a medical record, complaints by all three of her subordinates threatening to resign if she were not removed, and a direct request from the medical director of Mercy Medical Center that she be removed from her staff. It is undisputed that Ms. Romeka's supervisors concluded their investigation on May 10th and decided at that time that Ms. Romeka must be terminated. It is also undisputed that under MedStar policy, before a termination, not a suspension, not a discipline or a transfer, but a termination can be effected, a supervisor must engage an HR representative to conduct their own independent review of the termination decision. It is further undisputed that on May 10th, consistent with that policy, Ms. Romeka's supervisors referred their termination decision to a MedStar HR representative, and that on May 14th, that HR representative began an independent review of her behavior and performance the same issues that Mr. Osick and Dr. Rosen reviewed, including an interview of Ms. Romeka. This occurred all before her alleged protected activity on May 17th. Ms. Romeka may personally dispute the words in the emails, the affidavits, and the testimony of the witnesses in this case, and may complain about whether contemporaneous emails do or do not exist. But she does not, and she cannot, dispute that she engaged in the behavior I just described. And she cannot dispute that her supervisors followed MedStar policy for terminating her employment long before her alleged complaint was made. The Healthcare Workers Whistleblower Protection Act is, by its very nature, an employment retaliation law. It is intended to encourage employees in the healthcare industry to report unsafe and dangerous practices by their employers, and to protect those individuals for having done so. Therefore, this act is but a subset of all employment law, retaliation laws, and similar, like Title VII, like the Maryland Fair Employment Practices Act. In 1989, the U.S. Supreme Court established the federal standard for causation for all Title VII claims, both discrimination and retaliation in Price Waterhouse. In that case, the Supreme Court rejected the idea that Title VII required an employee to establish that her gender was the but-for cause of her adverse action, and instead adopted the motivating factor test. This court aligned itself with Price Waterhouse in its 2011 Gasper decision, where it adopted the same motivating factor test, quoting the U.S. Supreme Court for FEPA retaliation claims. 2 years later, the U.S. Supreme Court revisited the standard of causation for federal retaliation claims by announcing in Nassar that the motivating factor standard outlined in Price Waterhouse was no longer controlling. The Nassar court explained that when Congress took action to amend Title VII with the Civil Rights Act of 1991 as a result of Price Waterhouse, the legislature focused specifically on Section 2000E2 of Title VII, which covered status-based discrimination, discrimination based on race, color, sex, or national origin. To that section only, Congress removed the term because of and added explicitly that a plaintiff need only demonstrate that race, color, sex, religion, or national origin was a motivating factor for any employment practice. Importantly, Congress did not make any changes to Section 2000E3 of Title VII, which covers retaliation. The court concluded that because Congress carefully tailored the motivating factor claim, specifically added it to Section 2000E2, it necessarily meant that the motivating standard factor was not an organic part of Title VII itself, and thus could not be impliedly read to other sections. As a result, Title VII's retaliation provisions reads, it shall be an unlawful employment practice for an employer to discriminate against any of his employees because he has opposed any practice made unlawful by this subchapter. In Nassar, the Supreme Court found that the use of the word because in the statute was key. The court
yes. How do you see the Bostock fitting into this?
Bostock explains that but-for is not necessarily always the but-for cause. But-for, though, in but-for cases, it's about peeling back events to get to the event that creates the end result. You take away pieces to figure out when the adverse action would or would not have occurred. For example, in Ms. Romeka's case, you take away her protected activity on May 17th, it does not change, ultimately, the fact that she was going to be terminated. All the events leading up to it, including her decisions to terminate on May 10th by her supervisors, the HR consistent finding.
There's two planes on which this is being fought. There's the first one, which is what the standard is, and the second one, which is application of the facts. Sure. And my question really went more to the first one, and I think you were getting into the second. So if I could just stick to the first part of that for the standard. What is the difference if you say there could be multiple but-for causes on the one hand, or Bostock, and on the other, that any motivating factor, I mean, can a motivating factor be something that didn't rise to the level of actually being meaningful for the decision, like the decision would have been made afterward? Have you come up with a framework to pull those things together as far as really what the line is there?
Well, again, I think it's like peeling back the onion. It's figuring out, if I take this event away, would that have occurred? Would that result have ended up? If I take this event away, would that result have occurred?
And is it that anything that you answer yes to, if I take that event away, that's a but-for cause?
Exactly. That's right, Your Honor. And I think that's consistent with BASA. And
then just to carry the thread through,
yeah.
A motivating factor, you would say, is something that you could peel away and you would still have the same thing, but if that was something that was in your mind, that would have been enough to do it. That's the line I'm trying to.
Sure.
We've got the but-for cause beside the line. Where do you see the motivating factor related to that?
Well, motivating factor, I think, is a piece of one of those peels that you might be peeling away, right? But at the end of the day, a motivating factor might still not end up as the but-for cause of a result. Again, I think it has to be an event that occurs, a decision that is made, that has to be the cause of the end result.
But if the motivating factor actually motivated you to take that action, how is that not, in some way, a but-for cause?
Sure. If the motivating factor goes into your decision, then the decision itself is tainted, and that is a but-for cause, right? I don't disagree with that an individual can have a motivation to that is part of intent in the first place, of retaliatory intent. There has to be intent. In
your mind, is then a motivating factor that doesn't rise to the level of a but-for cause something that may have been something that was like an additional reason why somebody would have been happy to do it, but not actually the reason they did it, or?
Sure, that I think is probably a fair characterization. I mean, I think, for example, you have somebody who may or may not have been involved specifically in the termination, maybe knew of the event or the protected activity, might have been upset by the fact that the person engaged in that protected activity. That doesn't necessarily change the fact that at the end of the day that person was going to be terminated, or that events were leading to that termination anyway.
Does in comparing Title VII to our statute, I was looking for something equivalent to 1506,
mm-hmm.
and sort of the closest I could find is in the relief limitation provisions in for motivating factor situations. And it seemed to say that even if there was an independent basis for the employment action, if the impermissible motivating factor existed, the plaintiff could still obtain relief, although not damages or reinstatement, but just injunctive relief. And so that seems to suggest that in Title VII, at least in the status-based claims, that where motivating factor comes in, that an independent reason doesn't kick your claim out.
That's correct, Your Honor. That's correct.
Whereas 1506, we don't. That seems to say the game's over.
That's right. That's right, Your Honor. And that is essentially the difference between Section 2000E2 of Title VII, which allows for motivating factor, versus Section 2000E3 of Title VII, which does not allow for motivating factor and has been read, because of the use of the word because, has been read to require but for. And our position is that 1506 essentially is a codification of the but-for factor in this act. Would you like me to continue?
No, I'm thinking it through.
Okay. Turning back to Nassar and how the Supreme Court in Nassar defined because. The court explained that the phrase because is unambiguous. It has a definition. The idea that it doesn't have a specific meaning or that it can be interpreted in different ways does not make sense. It has a definition, as Justice Watts was getting to, by reason of, on account of. That is what because means. So reading its prior decision in Gross, the Supreme Court noted that the law's requirement that an employer took adverse action because of age meant that the employer decided to act, or in other words, that the age was the but-for cause of the employer's adverse action. Based on the use of the word because in the statute, the Nassar Court concluded that Title VII retaliation claims must be proved according to traditional principles of but-for causation, not the lesser causation standard stated in 2000E2, the status-based discrimination provision. And this requires proof that the unlawful retaliation would not have occurred in the absence of the alleged wrongful action or actions of the employer. So the plain text of the Act controls here, and that's exactly where the Court of Special Appeals began. Section 1502 of the Act provides that employers are prohibited from taking or refusing to take any personnel action as reprisal against an employee because the employee made a protected disclosure under the Act. That not only mirrors Title VII, but it mirrors Maryland's Fair Employment Practices Act statute, which itself provides an employer may not discriminate or retaliate against any of its employees because the individual has engaged in protected activity under the statute. The Fourth Circuit has since found use of the word because in federal anti-retaliation and whistleblower statutes should also be read in the same way as Gross and Nassar and Foster, which I'll get to in a minute. For example, in the case U.S. versus Mantech International, the Fourth Circuit found no appreciable difference between the use of the word because in the retaliation provision of the Federal False Claims Act and the language analyzed in Title VII's anti-retaliation provision. Now, Maryland courts have obviously turned to McDonnell Douglas, the burden-shifting framework used in analyzing employment discrimination and retaliation claims where there is no direct evidence, which is the case here and is often the case. Here, both the Circuit Court and the Court of Special Appeals correctly applied that burden-shifting framework. To reiterate or to just briefly go through McDonnell Douglas, the plaintiff must establish a prima facie case by showing that 1, she engaged in protected activity, 2, she was subjected to an adverse employment action, and 3, there is a causal connection between the two, like a contributing factor. If the plaintiff satisfies her prima facie case, a presumption of retaliation is made, and the burden shifts to the employer to present a legitimate, non-retaliatory reason for the adverse action of the employee against the employee. If the employer then meets that burden, the presumption of retaliation drops away, and the burden shifts back to the employee to show that the employer's stated reason is pretextual and that the real reason for the adverse action is retaliation. The final shift is that pretext stage. This real reason requirement is based on the expectation that a plaintiff in a retaliation case bears the ultimate burden of persuading the court that she has been the victim of intentional retaliation. In order to carry that burden, a plaintiff must establish that both the employer's reason was false and that retaliation was the real reason for the challenged conduct. So while Nassar altered the causation standard for claims based on direct evidence in retaliation cases, it did not apply its findings to claims where direct evidence does not exist because it did not need to at that time. The Fourth Circuit's 2015 opinion in Foster clearly and succinctly explains how the McDonnell-Douglas framework and the but-for causation standard should be applied in a retaliation claim. The Foster Court explained that under McDonnell-Douglas, a plaintiff must establish causation at 2 different stages. First, in making a prima facie case, and second, in proving retaliation and satisfying her ultimate burden of persuasion. Contrary to Ms. Romeka's reading of Foster, the court clearly stated that it would consider the applicability of Nassar to both stages, both the prima facie and the pretext stage. With regard to causation at the prima facie stage, the court noted that it is less onerous. It specifically said the employee's proof of causal connection between the protected activity and her discharge essentially was that she was fired after her employer became aware that she had filed a discrimination charge. While this proof far from conclusively establishes the requisite causal connection, it certainly satisfies the less onerous burden of making a prima facie case of causality. Turning to the pretext stage, the Foster Court then explained that Nassar's but-for causation standard is not a heightened standard. It does not demand anything more than what McDonnell Douglas already demanded in its real reason standard. In other words, a plaintiff can show that retaliation was the real reason for the adverse employment action. It will not necessarily be able to show that the harm would not have occurred in the absence of, that is, but for the defendant's conduct. Thus, the court explained that there are two statements. The real reason for employee's termination was her employer's retaliation, and the employee would not have been terminated but for her employer's retaliatory animus are functionally equivalent. The court ultimately concluded that Nassar had no impact on the causation standards already required at either stage. Now, Ms. Romeka agrees that McDonnell-Douglas burden-shifting framework is appropriately applied here, but she disagrees that the Title VII case law or Title VII retaliation law generally should be applied. She has presented no reasonable explanation for why this court should change or depart from long-standing jurisprudence governing remedial employment statutes that use because and the because construct like this act does. Ms. Romeka's argument makes no sense for at least 4 reasons. First, as this court knows, McDonnell Douglas is federal Title VII law. The idea that Ms. Romeka can pick some pieces of Title VII that best serve her and leave behind others is incomprehensible, and she points to no authority to support that position. Unless there is something specifically stated in the statute to the contrary, where some statutes do direct the causation standard specifically, if the burden-shifting framework of McDonnell Douglas does apply, then the entirety of that framework should apply. Second, if Ms. Romeka's insistence that the contributing factor standard should be applied at both the prima facie stage and pretext stages of the McDonnell Douglas framework is both illogical and frankly unworkable in practice, the McDonnell Douglas framework cannot be meaningfully applied by a fact finder where the same standard is used at both stages. Ms. Romeka's theory would first require that the plaintiff rely on the contributing factor standard to show a causal connection between her protected activity and her adverse employment action in making her prima facie case. The causal connection at the prima facie case can be proven by something as simple as temporal proximity, which is exactly what Ms. Romeka relied on here in making her case. Then, according to Ms. Romeka, once the prima facie stage is satisfied, the burden shifts to the employer to identify a legitimate reason for the adverse action. If the employer satisfies that burden, the burden then shifts back to the plaintiff, who again would only be required to meet the same contributing factor standard that she already satisfied at the prima facie stage. How can that be? There simply would be no need for the burden shifting in the first place if she is able to satisfy the ultimate case at the prima facie stage.
Well, but is that so when you have different levels of, I mean, at the prima facie stage, she's the only person who's presented any evidence. So you're just saying, has she carried that minimal burden to present something to get to that point? Then the burden shifts and the other side has to produce other evidence that there was a legitimate reason, and then you go back and then you're having an ultimate determination with more information than the other side having been able to weigh in. And I'm not sure, I understand your point about just the definition of because, and how we understand that and how it's been interpreted, but I'm not sure how your argument is, I'm not as sure about this argument that you get to that point and you've allowed the other side to weigh in and make their case, and now you're saying, well, has it still been there now that we've given an opportunity to see what all the facts are? I'm not sure why that's inconsistent.
Well, for example, if temporal proximity which does satisfy the contributing factor standard at the prima facie stage. If temporal proximity is all that the plaintiff still has at the end of discovery, that shouldn't carry the day and defeat summary judgment if there's nothing more to prove that temporal proximity there was nothing more beyond just a closeness in time of the events.
Right, but I think that's the point. In other words, if all you have is temporal proximity at stage one, then that is your prima facie case, and that's enough. And then if the burden shifts and somebody produces a document that says no in between there, and then you get to the other point, even if the standard's the same, it's going to be a different result because there's been evidence.
And that may be true, Your Honor, but I think getting back to the language of the statute here is what's really important. And frankly, that's what carries the day. Whether or not, sorry, yes, sir.
Finish your sentence now.
Whether or not you can find a way to work in contributing factor at the pretext stage, the language of the text of the statute itself is what should carry the day here.
As to the text of the statute, are you saying that temporal proximity alone establishes a prima facie case that satisfies the because language of the statute?
I think the causal connection, and if you're going to apply contributing factor, the case law has indicated that the burden is very low at the prima facie stage. And so temporal proximity alone will get you there. That's the case whether it's a Title VII. That's the case whether it is, frankly, any other statute, any other similar statute to this. Temporal proximity will be enough at the prima facie stage to meet causal connection or even as a contributing factor. Getting back to why it's unworkable, Your Honor, the Foster Court actually emphasized this point, clarifying that a plaintiff must establish causation at two different stages. And the court explained that the burden for establishing causation, like I said earlier, at the prima facie stage is necessarily less onerous than at the pretext stage. And as a result, that court held that the burden of causation must increase in weight at the pretext stage. Without this increase, there would be no need for a burden shift. And according to the Foster Court, that would be tantamount to eliminating McDonnell-Douglas framework entirely. My third point, to the extent Ms. Romeka relies on state and federal whistleblower claims to support her argument, she misinterprets their meaning. With regard to the cases interpreting the federal whistleblower statutes, Ms. Romeka argues that those cases require use of the contributing factor standard at the pretext stages, as she advocates here. That's fine. It's fine that they use contributing factor at the prima facie stage. They do not use it at the pretext stage. That is not what those cases say, as Ms. Romeka indicates. Those whistleblower statutes explicitly require application of a contributing factor standard at the prima facie stage. In fact, according to the cases cited by Ms. Romeka, once the prima facie stage is met, under those statutes, the burden shifting of McDonnell-Douglas then applies, and the but-for standard, or the real reason standard under McDonnell-Douglas, ultimately controls those cases. For example, Ms. Romeka cites to Morgan, a Federal Whistleblower Protection Act case, where the Federal Circuit Court listed the prima facie elements, including that the plaintiff must show his disclosure was a contributing factor to the agency's decision to terminate. Once the plaintiff states that prima facie case, the burden then shifts to the employer. And the language is very similar, almost the same as what we have at 1506 here. The employer would have to show, and the employee would have to rebut, that the employer would have taken the same adverse action or actions against the employee regardless of the disclosures made. Another example Ms. Romeka cites to Feldman, a Sarbanes-Oxley case, where the Fourth Circuit listed the elements, again, of a prima facie case that a plaintiff must satisfy, including a showing that the protected activity was a contributing factor in the unfavorable action. If the plaintiff meets those burdens or that requirement, the burden shifts to the employer to rebut with a legitimate reason. And the employee then has to show that the employment action would not have taken the employer would not have taken the same personnel action in the absence of the protected activity. This is quintessential but-for language. And this court's decision in Heller does control the day, we believe, frankly, considering the Maryland whistleblower statute. That follows suit. In that case, citing federal law, this court described that a plaintiff must first show that his protected disclosure was a contributing factor in the decision to make the personnel action at the prima facie stage. This court then explicitly stated that the burden-shifting framework of McDonnell-Douglas must be applied where the burden shifts to the employer, and the employer must show a legitimate action. The employee wins unless that action is shown by the employer that it would have taken the same personnel action in the absence of the protected disclosure. Again, that is but-for language. That is classic but-for language. If A, then B. If not B, then not A. In complete consonance with RadAmerica's argument here, there are other federal whistleblower statutes that do not explicitly require the contributing factor standard in its language, that instead rely on the word because, and that have been interpreted to follow Gross and Nassar and Foster in requiring but-for causation at the pretext stage. And that dovetails, again, nicely into my fourth point, that but-for causation is expressly codified, as I said, in 1506. That section, again, looking to the words, the explicit words of that section, it is a defense that the personnel action was based on grounds other than the employee's exercise of any rights protected under this subtitle. This language reads the same as the language in the whistleblower cases I just reviewed. It's strikingly similar to the McDonnell-Douglas real reason standard, which the Foster court explained was the same as the but-for causation standard. Again, as explained in Foster, a plaintiff can show that retaliation was the real reason for the adverse action, as opposed to the non-retaliatory reason put forward by the employer. And that person will necessarily be able to show that the harm would not have occurred in the absence, that is, but for the defendant's conduct. Moreover, the phrase based on, yes, Your Honor, yes, Your Justice.
We've been using the term, both sides, contributing factor here. Is that the same thing as motivating factor in Title VII?
I think they are different, frankly, Your Honor. I think, Justice, they are different. Contributing factor are events that occur. Motivating factor can be simply somebody's motivation in taking an action. They do have different definitions.
So status versus retaliation.
So, I'm sorry?
Status versus retaliation situations.
That's right.
So that, unless there are other questions, and I don't see any, that has taken you to the end of your time. So thank you, Ms. Curry.
Thank you, Justice Holder.
And we will turn back to Ms. Hahn, who has a little over 9 minutes left for rebuttal.
Thank you, Your Honor. I would like to begin by briefly returning to the question Justice Watts asked me about evidence of other employees who had backdated forms and been terminated. I would point out that there is testimony in the record about therapists regularly backdating forms, and that's at E262. Now, the distinction between practice and policy is one where the policy might have been termination, but it is in the record that it was happening regularly, and it's not in the record that people were regularly terminated. So that discrepancy is something worth highlighting for evidence of pretext.
Weren't there two different issues with her record keeping? One was backdating the assessment versus whether the consent form was in the file at all. And the consent form issue was the false medical record, the backdating they didn't seem to be as worried about.
Yes, I think so. And if I'm understanding Your Honor's question, I believe that the falsification of medical record, the issue was putting in the wrong date and losing the form, putting in the wrong date when that was discovered, I think.
Okay, I thought it was mostly based on the fact that she said the consent form had been filled out, was in the file, and in fact it never was.
I think that both of those issues contributed to it. Thank you. Next, I would like to respond.
That's very different. Those two issues are very different than just backdating. Saying that a form was filled out and it wasn't, and then putting it into the electronic record, that's a falsification, which is different than just backdating something that exists.
Well, the falsification of the record here, it's my understanding, was saying that it was still there from the beginning and then going back and dating it after that was discovered. I would also just like to clarify, not to justify this, but to make clear that actual consent was obtained in this case, that the patient's sister who was there with the patient was called after this was discovered, and it was verified that at some point there had been a form, but that it was lost. Just to provide additional context. I'd like to return to some points raised by our friends on the other side. In distinguishing between but-for causation and motivating factor causation, opposing counsel discussed needing to peel back the onion. But it's critical that the proper party is the one peeling back the onion. And here that means the jury, the trier of fact, is peeling back the onion to determine these credibility issues, to figure out, depending on the causation standard, whether something was the particular peel that needed to be pulled away. Second, as to the contention that Section 1-506 of this statute is codification of the but-for factor causation, I would again highlight that the words here are on other grounds, not on additional grounds, which the words on other grounds can be read only to request sole cause causation. So that's critical here. It stands for burden shifting. It does not stand for but-for causation for the petitioner's claims. Second, or third.
Before you turn from that, I just want to make sure I understand it. Can you, on additional grounds, would seem to indicate that that was a but-for cause and there were other causes. But that presupposes that the improper cause has to be a but-for cause for additional grounds to work, doesn't it?
No. What I mean to convey is that the language in Section 1-506 is making clear that for the employer, the adverse employment action cannot be motivated at all by the protected conduct. It cannot play any role in the decision.
And I'm trying to understand what in the language of 1-506 leads you to that.
I see.
It sounds like you want to say that for it to be interpreted the way that RadAmerica is interpreting it, it would have had to say additional grounds. Mm-hmm. But as I'm thinking about it, if it said additional grounds, then that would mean additional to the unprotected factor, which would mean that would have to be itself the reason, a but-for cause, but there were additional reasons as well. I'm not sure how that helps you, which is what I'm trying to figure out.
I see. If I could maybe think about that if I return to another point and come back, but I think additional grounds, if it had used language like that, that would contemplate a scenario where an employer could have more than one motivation in mind. Here, the General Assembly wanted to make clear that the employer could only have legitimate motivation in mind, not considering the protected conduct. I'm not sure that that's responsive to yours, but I'll think about it more as I respond here. Returning to the discussion of the significance of McDonnell-Douglas here, if it's wrong, if McDonnell-Douglas requires but-for causation, then Heller is wrong. Appellee's attempts to distinguish between the prima facie burden and the pretext burden in Heller, that is not something that was distinguished in that case. So that's a bridge too far. Additionally, I'd also like to emphasize again that this court is not applying Title VII here today. This court is not bound by Title VII here today. This court is not bound by Foster here today. So the fact that the Fourth Circuit decided to delineate the significance between prima facie and pretext in this manner, that doesn't dictate what this court does today. And consistent with Heller, it is entirely fine to go ahead and apply contributing factor causation at both stages. I'd also like to point out the whistleblower context discussion brought up by our friends on the other side. It's important to point out, we cited to those cases for the proposition that whistleblower statutes often use contributing factor causation. But it's important to note that under the Whistleblower Protection Act and the Sarbanes-Oxley Act, they do use burden shifting, but it's burden shifting that comes from a different place than Title VII's McDonnell-Douglas. Specifically, as observed by the Fourth Circuit in Feldman v. Law Enforcement, a 2014 case, it cites to Allen v. Administration Review Board, a Fifth Circuit case, which talks about how the independent burden shifting framework is distinct from McDonnell-Douglas burden shifting applicable to Title VII claims. It comes from the Wendell H. Ford Aviation Investment and Reform Act for the 21st century. So to the extent that the other side is attempting to compare their treatment of these different stages of burdens of production, it's comparing apples to oranges. Finally, I would just reiterate that what is at stake here is making sure that whistleblowers' rights are vindicated, that the courthouse doors remain open to them. In looking at the case law, including Heller, what is significant is in many of these whistleblower contexts, the claims get tossed out because the protected disclosure or the alleged protected disclosure doesn't qualify as such under the statute. To the extent this court is concerned about what contributing factor causation, what that standard might do in terms of leading to a deluge of claims, those fears are largely unfounded. Looking to other jurisdictions that adopt a gentler causation burden, there isn't a spike in claims. Whistleblower statutes fare about the same across the country, a low rate of about 9%. What's important here in this case is making sure that the General Assembly's intent to provide for broad coverage of whistleblowers affected. Again, the General Assembly saw fit to protect whistleblowers not when an actual harm is resulted from violations of Maryland's health laws, but when there is the chance of it happening because a health law has been violated. It's when the violation occurs, not when the horrible of horribles happens, when the loss of life, which is at stake here with things, especially radiation treatments to vulnerable patients like brain cancer patients. It's vital that the courthouse doors, and in particular the opportunity to present to the ultimate trier of fact, remain eligible to this key class of claimants. So for the foregoing reasons, appellant respectfully requests that this court remand to the appellate court with instructions to remand to the circuit court for a jury trial on the merits. Thank you.
Thank you, Ms. Hahn. Thank you both for your arguments. The court is going to take a brief 5-minute break before calling the next case, so nobody needs to rush up, but we will stand in recess for 5 minutes. Thank you.
All rise.